figured out who it was. I'd never seen him before at the last meeting.
Can we take our seats, please? Want to be here all night. We'd like to start the meeting, please. Okay, so our next item's the public hearing action on appeal of Planning Commission approval of a mitigative negative declaration and architectural review for a data center project located at 2305 Mission College Boulevard. Is that Director of Development Andrew Crabtree?
Thank you,
Welcome.
Mayor, members of the City Council. The item in front of you is a consideration of an appeal of the Planning Commission's approval of a mitigated negative declaration, mitigation monitoring and reporting program in fulfillment of the California Environmental Quality Act, or CEQA, and the architectural review per the city's zoning code procedures for a two-story, 495,610 square foot data center on a 15.7 acre project site located at 2305 Mission College Boulevard. Just to give you a little bit of an overview of the project, this is a data center, something we process on a fairly regular basis here in Santa Clara. We're fortunate in that regard. The data center includes a two-level building and then some outdoor uses, substation, generator yard, and equipment yard. Would note that the site is currently developed with an office building, a two-story building about 385,000 square feet. The zoning is industrial, which supports data center uses. And so the project went through the architectural review process. These are the elevations for the data center that were reviewed by the Architectural Review Committee, considered in their action to approve the project. So the timeline, the Architectural Committee did approve it on April 18th. Subsequently, there was an appeal by Lozzie Drury LLP, and who is representing the Laborers International Union of North America, and by Adams Broadwell, Joseph and Cardoza, representing the California Unions for Reliable Energy. And then based on that appeal, went to the Planning Commission. They considered the appeal. They went ahead and upheld the approval of the project and the mitigated negative declaration, et cetera. And then subsequently, their action was appealed. And so that's what's in front of the City Council tonight. The process, the focus of the appeal is on the environmental review process. The city did issue a mitigated negative declaration for this project following the procedures of CEQA. The mitigated negative declaration did conclude that the project, with the incorporation of mitigation measures, will not have a significant effect on the environment. There were 4 organizations that submitted comments during the circulation of the MND. Those addressed a variety of issues, which then the city responded to in a supplemental memo. And based in our analysis, we concluded that there was nothing raised in those comments that substantiated an environmental impact that had not been adequately analyzed in the city's process, and that our mitigated negative declaration was adequate. Some of the concerns raised were air quality impacts from the project, greenhouse gas emissions related to the project, noise, battery, cancer risk, other health risks. There was a concern about a procedural issue related to CEC, that's California Energy Commission approval process, and then just the adequacy of the findings that were made. We've responded to all of these concerns in the various documents. In making our recommendation, some of the considerations that are made by staff, we do look at zoning code and general plan consistency, and did determine the project would be consistent with those. It's a permitted use, as mentioned, in the zoning district. It's similar in scale to other industrial uses in the vicinity. As noted, the project would not have any significant environmental impacts has concluded our analysis. And there was a summary that, in response to the comments we received, that also verified that. Project is, as you see, an architectural style, modern architectural style that has been reviewed by our architectural committee per our code provisions and recommend and approved. And I just would mention too that in our environmental analysis, we've really looked at it, and we believe it's fully in compliance with the requirements of CEQA. The appellants, in our conclusion, have not provided substantial evidence that would support their appeal, and they've not made a sufficient argument for a different process and conclusion for the mitigated negative declaration process. So with that, staff is recommending to the City Council that you deny the appeal and uphold the Architectural Review Committee's adoption of the mitigated negative declaration and mitigation monitoring or reporting program, and that you deny the appeal and uphold the Architectural Review Committee's approval of the data center project. So with that, available for any questions you might have.
Okay, any questions of the council for Mr. Crabtree? Okay, seeing none then, Teresa, did you have, Councilmember O'Neill? Do you have questions of Mr. Crabtree? Yes, please, go ahead.
I apologize because I was trying to find it because I had looked at some of these emails and things, these letters. So it's the belief of staff that all of these different letters and things, and then even saying that we need some kind of ruling from the California Energy Commission and all of, various things, all these things that were that this project violates. And I wasn't there that night that this particular data center came to the Architecture Review Committee. I believe Councilmember Mahan was there. But most of the time, it seems like the data centers are starting to become kind of a little bit of a CEQA target in some ways. And we've never, everything, they're usually very clean operating. There's very few employees coming, so some of the issues that were brought up in some of this correspondence, they had some, arguments that I'm not sure are correct, but so it's the opinion of staff, if you've looked at some of these letters that have been coming in, that there's not a basis to that, like that this project has to go before the California Energy Commission. We've never, we have a lot of data centers, and I don't think we've ever had to have any of these other kinds, an Energy Commission ruling.
So there have been a number of letters submitted, including those that came today, late today, and staff has reviewed all of those carefully. There also was a letter from the appellants, and there was also a letter provided by SSL law firm, which is representing the applicant. And so, in the record, there's all of those are now part of the record on this project. The issues raised in the subsequent letters, in our opinion, in staff's review of it, our professional opinion, do not raise new issues beyond what had already been addressed sufficiently to sort of reiterate some of the concerns. But we think everything, and then it's also sort of, there is a CEQA process that we follow too, is that there is a comment period, and so really we're obligated to respond formally to things received during the comment period. Additional comments that come in are information that's something you can consider, but they do not raise new concerns beyond what we've already analyzed. The CEC approval process, it's a standard condition that when we approve these types of projects or anything that has like a diesel generator in it as a backup generator, it's a fairly common thing. There are potentially other regulatory agencies out there that have an approval process, and we, as a condition of our approval, said you also have to get those approvals subject to the rules of that agency, whether it be the CEC or a restaurant that has to get
the resources board,
or different things that are out there. So in no way is that, in our again professional judgment, something that would delay or affect the CEQA process that the city conducts. It doesn't change our approval process that we believe is the first step in that process, and then they go through their subsequent approvals prior to their operation or ongoing basis as need be.
Thank you.
Thank you, Vice Mayor Watanabe.
Thank you, Mayor. I was concerned when I read about some of the environmental concerns that were raised, specifically as outlined in your report about the air quality impacts, the greenhouse gas emissions, noise impacts, and reading through some of the letters that were submitted by both parties. And I mean, I'm not a scientist, but just the breakdown of the concerns gave me concern as well, because mainly the proximity of this new data center, where in relation to the neighborhoods. I mean, Lake Santa Clara is right across the street from where where this new data center will be built. I mean, there will be a demolition, a rebuild. There's residence on both sides, right off of Agnew, and then you've got the Creek Trail right there as well. And I just have a lot of concerns about that. I mean, I live further down the street as well, so I know exactly where this is going in now and how many residents are living out there.
So when we look at air quality impacts, generally there's one category which is during construction. So fairly typical anytime there's a construction activity, and there's then standard mitigations to try to control dust and that sort of thing during construction, demolition, and so forth. And then in this case, because it has diesel generators as a backup energy supply. And again, that's not that unusual for an industrial building to have diesel generator backup. In this case, because it's a data center, that's particularly something that's there. But the way those normally operate is that they're not on unless there's a blackout, which is a fairly rare occurrence, or for periodic testing. And so, we looked at all that. We look at, if as on a regular schedule there is testing, what are the emissions from those generators during the half hour or hour, whatever it is that they're on for testing. All that is analyzed and looked at. Just for a bit of reference too, diesel trucks or vehicles in the area are generally a much larger contributor to air pollution than some generator that runs for half an hour on a monthly basis or something like that. So all that is analyzed. I think the point of contention, as I understand, is that what were the thresholds that we used? How did we conduct our analysis that's being raised by the appellant? We really followed the city's standard procedures, the same procedures that we use for all of these. We rely on standards put forward by like Bay Area Air Quality Management District, other established agencies out there that have determined, and using those standards, the analysis concludes that there are not or would not be significant impacts through this project. So that's the basis of our conclusion is we're following established procedures, recognized standards that are out there. The appellant has put forward an argument that we should do something different, but that's the way we normally do it.
And then I'm looking at the public contact that was made. It looks like it was posted in, 3 conspicuous locations and within 300 feet, and then property owners were notified as well. Did we receive any responses from any of the neighbors about the project?
No, I'm aware of. We've not heard of any concerns from neighbors. It's all of the concern has been really focused from the appellants as we've gone through the public hearing process.
Okay, thank you.
Okay, any other council comments? Okay, thank you. Since this is a public hearing and appeal, we can now hear from the appealing party. Please come forward. Good evening.
Good evening, Mayor and Council. My name is Colin McCarthy. I'm an attorney at Adams, Broadwell, Joseph, and Cardozo, one of the appellants in this matter. So I'm here tonight on behalf of California Unions for Reliable Energy. We previously submitted a number of comments and letters to the council on this project and appealed the decision, and really those issues can be broken down into 2 main categories, the first of which you heard a little bit about tonight, which is the Energy Commission's jurisdiction. And I would like to correct a few statements that I believe to be incorrect or misleading characterizations of the project. So first of all, while sure there are usually a number of different agencies involved in projects, say I think the example was restaurants or any project with a generator, the California Energy Commission has exclusive statutory jurisdiction over power plant projects that are greater than 50 megawatts. And so while ordinarily you might not think of backup generator facilities as a power plant facility in the normal sense of that term, the California Energy Commission has interpreted its statutory jurisdiction over power plants to include backup generating facilities. They have exercised this jurisdiction over other power plants other data centers in Santa Clara. But it is a little bit rare because it has to exceed that 50 megawatt threshold. So that's what brings it into the Energy Commission's exclusive jurisdiction. We submitted as attachments to one of our submittals to the city correspondence between the applicant and the Energy Commission, making clear in which the Energy Commission made clear to the applicant its jurisdiction over the backup generators for the project. And so the reason this is significant is because the Energy Commission's jurisdiction is exclusive, and actually the statutory grant in the Warren-Alquist Act, the Public Resources Code, says that the Energy Commission, a certification, which is the normal process, which is the license issued to power plant projects, is in lieu of local approvals. So that means that for large power plant projects that are normally going through the Energy Commission's process, they apply to the Energy Commission, and those permits are all that's necessary for that. They don't need the normal local approval land use kind of process. Now, certain projects that are less than 100 megawatts and more than 50 megawatts can apply for what's called a small power plant exemption. And through that process, it's basically the Energy Commission can look at the project, go through its CEQA process, it's the lead agency, and make a determination based on the environmental impacts and other statutory requirements that a project is exempt from its jurisdiction. At that point, it can go, the project would go to the local approval, to the local government for the normal permitting process. But until that determination is made, then you can't decide that the project is qualified for a small power plant exemption or that the Energy Commission would make any particular determination. That the project has to apply to the Energy Commission for that, that formal determination and then go to the city process. There's been recent, I think, Santa Clara projects with the Energy Commission where they've done a second environmental review process and said, under the law, the Energy Commission is the lead agency for these projects, and then the way it works is that the city can then rely on the Energy Commission's environmental review process to make the necessary findings for its approvals. So none of that has happened here. The project has 75 megawatts in backup generators, so it exceeds that 50 megawatt threshold and is therefore subject to the California Energy Commission's power plant jurisdiction. The second issue I would like to, or second kind of category I'd like to touch on is the environmental impacts that we raised in our comment letters. The first two areas are kind of relate to a common issue, which is that in the analysis that was performed, the impacts were never analyzed with all the backup generators operating at one time. And so, at least for particularly with regard to noise, it was never analyzed the noise levels that would occur from 120 backup generators operating on one occasion. And while normally it's kind of ordinary process to do these analysis based on testing schedules and things of that nature, but most projects don't have 120 backup diesel generators that would be operating simultaneously, which would result in potentially significant noise levels, as well as potentially significant NOx emissions, which is what we raised in our comments, which were prepared with the assistance of a technical expert on these issues. Excuse me. The city's response to that, in the response to comments, was effectively that it would be too speculative to assume that a power outage would occur. And to that, I would point to the fact that these projects, the applicants necessarily felt it was required to include these 120 backup generators as a necessary component of this project in expecting that power outages very well may occur. And that's the unfortunate nature. We submitted documents along with our comments originally, which just had a link to the SVP website where you can monitor the power outages that occur in your neighborhood. And so under CEQA, you're focused on the environmental impacts that may result from the project. And in this case, it's reasonably foreseeable that all those backup generators will be required to operate at one time. And so, as we point out in our comments, when all those generators are operating simultaneously, you have potentially significant noise and air quality impacts from NOx emissions. So the last environmental impact we raised in our comments relates to greenhouse gas emissions. And this is really a kind of evidentiary type issue under CEQA, in that the city's analysis for the project's greenhouse gas impacts was to compare the project's consistency with the Climate Action Plan, which is a procedure that the city regularly does. However, in this case, the city's current Climate Action Plan was prepared for the city to achieve its 2020 emissions reduction targets. In this particular case, the project very well might not begin operating by that point. It sure will operate well beyond that point. And to say that because the project will not interfere with achieving 2020 targets, that's the evidence relied on to conclude that the project will not have significant greenhouse gas impacts. That conclusion is not supported by substantial evidence. And we actually, our expert submitted comments on this point and concluded that substantial evidence supports a fair argument that the project may have a significant greenhouse gas impact, and therefore an EIR is required. So what we're requesting of you today is to grant our appeal on this matter, to overturn the decision to adopt the MND and to grant architectural approval for this project, to direct the applicant to go through to apply to the CEC, to go through the CEC's process. First, the CEC has a public involved environmental review process of its own, and then following the conclusion of that process, the applicant could return to the city for the approval. The alternative, and this was mentioned earlier, and I didn't actually see this in the conditions, but to impose a condition of approval requiring that the applicant apply to the CEC and obtain whatever approval the CEC determines is necessary prior to the issuance of any building permits for this project. And that's just about my time, so I'm happy to answer any questions.
Okay, thank you for that presentation. Any council members have questions? The appellant? Councilmember O'Neill?
I'll ask a question, but aren't we kind of talking about two different, the city could go ahead and approve this on a land use basis, and if there would be a CEC requirement, wouldn't that be a parallel process outside the process that the city's process for accepting the mitigated negative declaration and granting the approvals that we've granted?
City Attorney?
It sure sounds like it. I mean, I just don't understand why the city would be even involved, because if they need to go to the CEC for some kind of permit on the generators, then they need to go to the CEC for some kind of permit on the generators. I don't know why we would need to order them there. Anyway, I'm trying to. I have the same question as you have.
Do you have a
Yeah,
response
so,
to that?
one issue that, so the process in itself was directed that under the statute that you would apply to the CEC, who has the expertise, who has been statutorily charged with approving power plant projects, to make the determination on where and how and whether a particular project is appropriate, and to shape to work with the applicant to shape how that project occurs. And so to go ahead and grant an approval for that project before the CEC has weighed in and made a determination whether the project qualifies one way or another for a particular exemption, kind of turns that process on its head and raises questions about what project is being approved, whether the CEC's review process, and the CEC is actually statutorily the lead agency on power plant projects. And if the project didn't qualify for a small power plant exemption, it would go to the certification process, which would be in lieu of the city's approval process.
Thank you. I don't
Okay.
necessarily agree with you, but I'm not an attorney.
Thank you.
All right, thank you. No other questions from the council, so if we have the challenged party.
Actually, Mayor, there's two appellants. Although
Oh.
my last name and the Cardozo's firm's last name are similar, we're definitely different appellants. So I assume I have my 10 minutes. I don't think I'm going to take 10 minutes, actually. I appreciate
I'm
the
sure I've
hour.
ever had two appellants, so is this 10 minutes also? Yes, go ahead if you.
Thank
Yeah.
you, Madam Mayor, members of the
Okay,
council.
two, all right.
My name is Michael Lozo. I'm with the law firm of Lozo Drury, LLP. And we represent the Laborers International Union of North America, Local 270. I just want to mention that we did not send any letter in today, nor did I receive any letters, so I'm not in any position to comment on whatever might have been received today. But we did not send anything in prior to today's hearing. I want to thank you for considering our appeal. We think that the evidence and our concerns, I'm going to focus on air quality impacts. We think the evidence still indicates that a fair argument exists that the project may have a significant air quality impact, in particular, the emission of nitrogen oxide, NOx, N-O-X, I'll call it for short. And just to give you some bearing under CEQA, what applies is a fair argument standard where two experts disagree on opposing views on an issue. That's a fair argument, and expert evidence is substantial evidence. And so where there is a fair argument that a project may have a significant impact, and in this case I'm going to focus again on air pollution, then you can't rely on a mitigated negative declaration. You have to prepare a full environmental impact report if there's that possibility, again, based on substantial evidence. So the two issues I want to focus on regarding NOx is first, as the planning department had indicated, construction emissions from the construction of the project and operational emissions. On the construction emissions side, construction emissions of NOx, our consultant reviewed air modeling in light of a construction schedule which we received at the Architectural Design Review Committee. We didn't have it prior to that. It wasn't attached to the MND. We received it at the architectural, in the process of that design review committee. And the construction schedule lays out the timeline for construction, what kind of equipment's going to be used, how long it's going to be used. So it's critical to the air pollution modeling that's done for these types of projects. And our consultant reviewed that construction schedule, all the phasing and the durations that were identified there, and determined that the construction schedule in that document was 61 days longer than what was analyzed in the MND. When you have a longer construction period, it's easy to imagine you have more pollution. Things go on longer, more equipment's being used for longer periods of time. So that was the analysis they did. They reran the modeling in order to see what effect that would have and compare it to the thresholds that, again, your director indicated are relied upon by the city that are prepared by the Bay Area Air Quality Management District. They publish a threshold of significance for NOx of 54 pounds per day. And mind you, in the MND, even as currently proposed, based on what was included there, the analysis using whatever, not the construction schedule we were handed at the design review committee, but whatever was used, came out and concluded that 51 pounds per day of NOx were going to be emitted after mitigation from this project, just 3 pounds per day under the BAA QMD threshold of significance. When our consultant reran the model with the longer period of time, comes out to 57 pounds per day, 3 pounds over the significance threshold relied upon by the city. So what that means is, contrary to the MND's conclusion that NOx emissions are going to be less than significant, because it's 3 pounds over the level that everyone agrees is the level that indicates a potential significant impact, there's a fair argument based on substantial evidence, which our expert provided rerunning the modeling, that this project may have a significant impact from NOx emissions during construction. So it's that simple. That's one problem with the ISMND, or the initial study and the mitigated negative deck. Secondly, we also looked at the operational emissions. So operation of this project also may have significant air quality impacts. Again, the mitigated negative deck did a calculation, and similar to the construction, came out with an analysis that, again, it was 51 pounds per day. Again, 3 pounds less under the BAA QMD. This is just this one project. Under CEQA, you also have to do a cumulative impact analysis. And in the case of Santa Clara, as the director again indicated, in some ways it's a blessing. You've had many data centers. In fact, you've had about 37 data centers. But none of those are considered together with this data center in terms of all that NOx emission, that they each individually probably emit somewhere close to the same thing, just shy of the BAA QMD threshold of significance for NOx. And yet there's 37 data centers in this city, all of which draw power from the city's power plants, which in turn also emit a certain amount of NOx from the gas-powered plants. So even that alone, just that's not considered at all in the MND. Whatever the additional cumulative emissions of NOx from all 38, including this one, data centers might be emitted. We don't know what that number is for all of those plants. So the cumulative impact analysis of the MND, we think, is inadequate because it doesn't actually address, it doesn't consider the NOx emissions of those similar projects in this particular city together. And that's what you have to do under CEQA. You have to look at whether, taken together, all of those data centers will have a considerable impact, cumulative impact on the environment. And I would be concerned. They're all located here. They're all emitting NOx right here. This is not like other cities where if you have data centers, they're getting spread out from they're drawing power from the grid. These are all drawing power from your plant that's not too far away, I guess near the airport's the main one, which are all emitting these NOx right here. So we think that adds to the concern about the cumulative impact analysis as well. So these comments were made in the supplemental comments, and those have not been responded to. We've never gotten a technical comment back on, for example, the construction emission analysis. The only, in one of the assertions at the Planning Commission meeting was that, it can't be right. It sort of assumed weekends would have construction, when in fact it doesn't. It assumes 5 days a week, which is our understanding of what the construction schedule is. No one's contested its accuracy. No technical analysis has been done that we're aware of to rebut that. And that, by definition, is a fair argument. If we have a reputable consultant running the air modeling that everyone runs, using the construction schedule that was handed to us that is not the same as whatever was used in the MND analysis, then we have evidence, substantial evidence of a fair argument on the operational side. And for the cumulative impacts on, that was the construction side. For the cumulative impacts on the operational side, again, there's never been, the only response we have is, oh, well, but it's underneath the threshold for this one plant, so that covers cumulative as well. That's not what the regulations say. It says you're supposed to take, when you have one or more projects or two or more projects, you take them together, and together, if they're considerably cumulative, you have a problem. So you have to, someone has to look at those other 37 and think about how much NOx have you accumulated in your city to date, emitting from the operation of the facilities themselves, and not forget the fact that they're also drawing power from the same power plants, which happen to be municipally owned here, which are also emitting NOx. So that cumulative number needs to be figured out and analyzed, and that we haven't got a response. That's not in the MND at all. So we think it's incorrect as a matter of law, as well as there's a fair argument based on our submission that it might cumulatively exceed that threshold of significance if you look at all of those things together. So those are the two things I wanted to focus on. I do appreciate your patience tonight and your ability to hang in there. But if you do have any questions, I'm here to answer questions and appreciate your time.
Thank you for that. Any questions from the council on the presentation? Seeing none, thank you very much for your presentation. So now we look at the challenged party. Please come forward.
Sorry to be challenged party.
You're the challenged, according to my thing here, yeah, yes,
Very
you're
good.
the challenged party.
Thank you very much, and I'll turn this over to
Yes.
the experts shortly, but just wanted to start as the owner representative. My name is Clark Michalak, here on behalf of the owner. We are an active owner in this community. We own several buildings in this city. We've owned this asset for several years. It was a single-tenant building. When the tenant vacated at the end of 2016, we proactively came to the city and discussed their plans for this site, the zoning, the general plan, and what they would like to see at the site. And we've spent the last 18 months working with your staff to collaborate on this project, the design, the process, and complete this CEQA process. We received unanimous approval, as you heard, at Architectural Review Committee and at the Planning Commission, and are excited to be here for your approval consideration this evening. So now I'll turn it over to our attorney, Zach Walton with SSL. Thank you.
Thank you. Good evening.
Good evening. So we did submit some additional information tonight. I won't repeat that chapter and verse here. Just let me touch on a few points. Now, the first thing I'd like you to know is that the arguments that the appellants have presented to you are exactly the same that they presented to the Planning Commission. The Planning Commission considered all this information and unanimously approved the project. The appellants have not presented any new information to suggest that that decision was an error. Now, and you heard it just a moment ago, but the unions here, the appellants would have you believe that provided that they present you with the opinion of an expert that a project may have significant impacts, you cannot approve a negative declaration. Not for this project, not just for this project, but for any project. But of course, that's wrong. An expert opinion that is based on errors and mistakes has no credibility. And therefore, it does not amount to substantial evidence. The staff report and the responses to comments do an excellent job of highlighting these errors and mistakes. We asked an additional environmental consultant, Ramble, to take a look, and they identified even more errors and mistakes in these opinions. I'll give you just one example. The unions have maintained that emissions from construction equipment should have been calculated based on maximum daily emissions. And had this been done, they claim that the project would be deemed to have caused a significant impact. But the city evaluated emissions consistent with the Bay Area Air Quality Management District's guidelines. And those guidelines state explicitly that emissions should be calculated based on average, not maximum emissions. So this expert opinion saying otherwise is objectively wrong. And because of that, they have not presented evidence of a significant air impact. A closely related issue concerns the selection of significance thresholds. The unions have stated repeatedly that the city should have evaluated impacts against different significance thresholds. And had the city done this, then it would have concluded that the impacts are significant. Now, the issue about maximum versus average emissions is a good example. Now, case law is clear that the city has substantial discretion in selecting which significance threshold to use. And to use the threshold that's established by the Air District, the agency with expertise in the field, particularly in the Bay Area, is inherently reasonable. The unions may want the city to use a different threshold, but that is not evidence of an impact. You heard this again just with regard to the claim that cumulative impacts were not considered, and that is objectively wrong because the Air District's significance thresholds are specifically designed to address cumulative impacts as well. There was a claim that that issue was not addressed in the response to comments. That also is not correct. This issue was addressed front and center. The appellants have also alleged that the city's evaluation of greenhouse gases is flawed because the city did not quantify emissions, but the guidelines, the CEQA guidelines state that lead agency has significant discretion in how to evaluate greenhouse gas emissions and that a quantification is not necessary if a project is consistent with a regional plan to reduce greenhouse gases. And that's the case here. The project is consistent with your clean air plan. And therefore, a quantification is not necessary. Now, you've heard the criticism that because the Clean Air Plan is designed to implement the AB 32 requirements through 2020, that somehow that should mean that you can't rely on that information at all. But that's not true. You can't disregard the compliance of that Clean Air Plan. But also, when they are talking about greenhouse gas emissions, they're really talking about the indirect emissions that are associated with the power, the generation of power that Silicon Valley then purchases. And I think we all know that the utilities are under ever-increasing obligations to increase the renewable portfolio standard and to reduce their emissions. And so this is not a situation where any information has been suggested that this individual project is going to cause a significant impact on the regional issue of greenhouse gas emissions. We also heard this about concerns about claims that impacts from operating the backup generators, the standby generators during an emergency were not evaluated properly. Again, the city evaluated the standby generators consistent with the Air District's CEQA guidelines, with their own permitting handbook, and with the Air Resources Board's air toxics control measure. And none of these require that you quantify impacts during an emergency, and for good reason. As any estimate of impacts during an emergency would be pure speculation. We don't know when an emergency will occur or for how long. Reference was made to going to the Silicon Valley Power's website and examples being provided of instances where there were service disruptions. The staff report that was provided to the Planning Commission documents how over the past 12 months there's not been a disruption of service where this project would be located. So, excuse me. So any guess about the impacts that could occur during an emergency would be speculative. And environmental impacts are not to be calculated on the basis of speculation. And finally, we've heard the argument that the city lacks jurisdiction to consider the project because of the jurisdiction of the California Energy Commission in relationship to the standby generators. And while the Energy Commission may have jurisdiction over the standby generators, they certainly don't have jurisdiction over the data center. And in fact, a precedent has already been established about how to deal with this exact issue. And it concerns the McLaren data center project that you all approved just last year. After the city approved that project, they then applied to the Energy Commission for the small power plant exemption that you heard. And the Energy Commission just recently put out its environmental assessment of that request for an exemption. And that exemption, and that analysis rather, relies extensively on the environmental analysis that the city put together. And so the precedent has been set about how to do this, and we're following that precedent. We're available to answer any questions that you have. We believe that staff has evaluated this project properly, and we urge you to approve it. Thank you.
Thank you. I think we might have a question from Vice Mayor Watanabe.
Thank you, Mayor. The gentleman that spoke earlier, you mentioned that this is, I guess, your you're representing the property owner?
Owner, yes.
Yeah. I understand from reading the documents, there was an R&D there prior to the business closing down.
Yes.
What type of R&D?
It was a General Dynamics. It was a government defense contractor. It was a single-tenant building that had been in operation for a long time. We feel that we are reducing the impact on this site from that 360,000 square foot office building with parking and people.
Okay. Now, I mean, General Dynamics is going to be a totally different business than what the data center is going to be, right?
Correct, yeah. General Dynamics has vacated the building. That's unfortunate. I wish they were still there and still paying rent, but they have reduced their footprint. They are, I believe, now in North Santa Clara, but they are in 80,000 feet, so they did not need the space to this scale. This is a different use.
Yes, okay, because reading the report, I mean, it states that the the proposed structure is comparable to the prior use on the site, which was a two-story, 358,000 square foot office R&D building and parking lot. Based on that, it doesn't sound like it's the same. It's not comparable. I mean, a data center is not General Dynamics.
Yeah, it's not the same tenant use. I think what they're saying is that this is, I don't know the sentence exactly, but that it's still within the zoning and that it's still a similar structure and that it's a two-story building with a parking field surrounding it. But
Now, I've heard two terms used tonight. One is, it was referred to as a power plant and a data center. What is
Right.
the difference between a data center and a power plant? Because I've got two different images in my mind.
want to speak to that, experts? I mean, a data center is not a power plant. This is servers to serve kind of cloud tech space. And your city is very attractive because you have a utility in Silicon Valley Power. This is located across the street from an existing substation you can tap into immediately before even producing the structures on site. And there's great fiber loops under Santa Clara that basically this is the ideal location for this type of use.
Yeah, normally when we're thinking about a power plant, we're thinking about the generation of power and sending electrons to the grid. What's happening here is a function of how the Energy Commission evaluates its jurisdiction. And because if you aggregate the nominal power of the standby generators, and you aggregate those, then you exceed 50 megawatts, which is the standard threshold for Energy Commission evaluation. There's been discussion with the Energy Commission staff, for example, about whether standby generators actually do in fact qualify as a power plant that would be subject to Energy Commission jurisdiction. That's why it's a little bit of a curious thing. And I think that's also one of the reasons why, and in fact, I spoke with Karen Douglas at the Energy Commission about this issue because data centers are being considered by Santa Clara so much. She actually discussed the possibility of entering into an MOU with you all about how to process this, recognizing that it's appropriate for the city to evaluate the project first, and then if it does cross that threshold value, then the Energy Commission would consider the small power plant exemption.
Because to me, I mean, I'm thinking that the kind of, well, data centers, they don't put out that much noise. But however, if you were to find it necessary to use these generators, there could be, I mean, a large increase in noise. That's what I'm hearing.
Well, yes, although the standby generators are only to be used in the event that there's disruption in power. And so these are not, this is not equipment that is used regularly. They will be tested and maintained. And so emissions, for example, are calculated on the basis of that. But you're not going to be seeing the regular operation of these generators, and hopefully, you know, there won't be any kind of emergency condition where you'll have to operate them for any significant amount of time.
The reason I ask these questions is because of the, like I said earlier, the proximity to the neighborhoods.
Sure.
And I mean, there's neighborhoods right across the street and also adjacent to the property. But also, and I know Mr. Mercurio was, well, he was in the audience earlier, but I mean, Levi Stadium is probably within a half mile of where this um, new business will be going in. You also have Great America, again, within half a mile. And you also have San Jose Airport, not that far away, which is, there's a creating a whole nother issue out there right now with noise and other, noise pollution, basically.
Sure.
So, so my concern, I mean, you're probably understanding, is for the neighborhood and what this could possibly do to the neighborhood, the demolition, the construction, and and going forward. So, as a resident of the area and within a mile, and just knowing what those residents are going through right now with several other issues right in their neighborhood, I have some concerns about the project.
I appreciate that. One thing I'd just like to point out again is that the potential for effects from this project to combine with others, just as you have identified, those are those are the cumulative impact types of issues that we consider. And again, the Air District's rules are expressly designed to address those considerations. There also was evaluation about the operation of the generators when they're tested and maintained, and what emissions and so on could be like during that. And as a result of the city's evaluation, you all have developed a mitigation measure that restricts operations to address those types of concerns. So that's an issue that's been disclosed and evaluated, and a mitigation measure has been put in place to address it.
I don't know if it's worth going back to the aerial, but just to identify that this is a limited residential community and that this is zoned industrial. And again, that we sort of went proactively to the city to discuss that we would be totally open to building residential in this location. And basically this was part of the city's plan, that they felt this was a great use for this site and that actually the community would benefit from reducing the operation of the site to basically a box of servers. So we recognize that concern and want to be considerate of it.
Okay, thank you. I have no further questions. Thank you.
Thank you. Councilmember Colstead?
Would you like a technical
Thanks, Mayor.
comment on decibel levels? We do have.
Actually, if you guys could just stay there for a second, I have a couple questions and it might answer some of your concerns. The General Dynamics was the previous tenant, and you're proposing to move on in. How many employees would you estimate General Dynamics had that worked in that 300,000 square foot building? Ballpark.
Yeah, we'd say maybe 4,000, 5,000.
And how many people work in a data center?
30?
One that size, about 30.
So the average daily trips going back and forth to the building are going to be much, much less with a data center?
Precisely.
And probably the biggest noise generator during the business day, or because you probably don't run the air conditioner that much at night, but the air conditioners on the roof, that's probably the biggest noise maker?
Mayor and council members, my name's John Watts. Yeah, there's decibel requirements you have to meet levels day and night to obtain planning commission approval and permits. And all of that's taken into account. The air conditioning, the generators, anything that causes sound on the project, and there's mitigation measures put in place, such as sound enclosures at the generators and walls built around the generators that are high enough and thick enough to deaden the sound to where you meet those decibel levels required at the property line to be good neighbors.
So you got a building that's being proposed that has less people, that will create less traffic. Of course, you'll consume more kilowatts, which is good for us. And you've taken all of the measures to mitigate sound, et cetera, going forward. And you clearly explained how the the estimated pollution is going to be significantly less in CO2 and NOx than was previously estimated. So I'm wondering, I can't think of a problem with this project.
Can't either.
Okay.
Okay, thank you very much. I don't see any further questions. Next, I'd like to go to the public. If there's any public members like to speak on this. Okay, seeing no public members, if the appellants would like to make closing statements, 3 minutes each.
Yes, thank you. Just, I'll be
Rebuttal
brief.
statements.
Yes, just to respond to a few points that were brought up. First, with regard to the issue of greenhouse gas emissions, as I mentioned before, that our primary argument was that the city's conclusion that the project would not have significant greenhouse gas emissions is not supported by substantial evidence, which is a CEQA way of saying that the analysis has been done to support that over the duration of the project. So a lot of times when you do use numeric thresholds, if you can compare those to say that these are the emissions of the project moving forward, this is going to, we can compare, that's going to be a constant. And so but in this case, when you tie the analysis to something like a climate action plan, which was prepared with a particular goal in mind, essentially what we're saying is that to say that the project will not interfere with achieving 2020 goals does not provide substantial evidence beyond that point, because state goals, as I've mentioned, are going to be ratcheting down. The climate action plan wasn't prepared to necessarily to achieve those goals. And so to say it's consistent with that doesn't tell you anything about whether implementing those measures will achieve a certain reduction moving forward. And so to that point of 2020, absolutely you can rely on that to conclude that the emissions will be less than significant. But beyond that point, that's not a threshold of significance that applies to conclude one way or the other. The other issue would be saying that the CEC doesn't have jurisdiction over a data center. It has jurisdiction over a power plant. That's creating a split in this project that simply has not been established in the city's process. All these documents, all these approvals refer to a single project. And so if the city wishes to say that this current approval applies to the data center and not the backup generating component, that's one thing. But right now, the approval that you are granting applies to the project as a whole. And so the backup generators are necessarily a component of this data center, and together make that one individual project, which exceeds the, as we discussed earlier, the threshold of significance, or the 50 megawatt threshold, excuse me. And then lastly, the McLaren data center was brought up. I think that's an example of, through the CEC process, that project change, and actually looking at the environmental review document, there's a statement in there explaining the CEC's jurisdiction, and that the city can now rely on this document to grant its approvals.
Thank you.
Thank you.
Thank you very much. Yes, sir, please come forward.
Thank you, Madam Mayor. First, Mr. Common is misleading the council about what the modeling that was done by our consultant and we submitted on June 12th, which was modeling an average NOx emission, not a maximum, as he alleges and said last meeting as well. And you can look on page 5 of the technical comment we submitted by SWAPE, and that, there's 2 tables. They're each labeled mitigated average daily construction emissions. So it's apples to apples, comparing it to the BAA QMD threshold and the city's threshold. So that's simply wrong. So if anybody's saying anything wrong, that's where it's coming from right now. In terms of how could the Air District have addressed 37 data centers in enacting regional guidance, they didn't. The regulation says cumulative impacts refer to 2 or more individual effects which, when considered together, are considerable or which compound or increase other environmental impacts. I'm citing from the CEQA guidelines. So the NOx emissions of the 37 data centers plus this one, plus whatever NOx emissions are going to come out of the city's power plants from 38 data centers, have ever been considered together, quote, considered together. They just haven't. It's some generic thing where each data center is a few pounds per day under, just barely under, an average daily emission threshold. Mind you, the rest of the state, Southern California does use a maximum for the same exact number, 54 pounds per day, but it's a maximum. They would clearly be over if that was the threshold being applied. But they've never been considered together. And in this particular circumstance, they wrote a regional guidance. It is a good threshold to look at. But in terms of having this many data centers, which are coming here because of the municipal power and that municipal power mission, I think you have an obligation to understand what the total cumulative impact might be of NOx emissions from all of those data centers plus the power plants. And it's a fair argument. That's all we have to meet in order to trigger an EIS, a fair argument that there may be a significant NOx problem from all those data centers concentrated in one town and its municipal power system. So I think you should look at what we wrote and what our consultant wrote and think twice about whether or not you actually have a valid MND in place before you move ahead. And the baseline comment made by Councilmember Kolstad, that's simply wrong under CEQA, with all due respect. It's the legal requirement, and what was applied in the MND is there's nothing there. There's nobody there right now. And that's what the evaluation does not try to credit itself with whatever was going on with the previous tenant. I don't think there's any information in the record about, I'm not aware of it at least, when they left or anything like that, but that's not what was done in the MND. So that baseline notion is not legally what's been applied under CEQA. And with that, I appreciate your time again.
Thank you. Okay, challenge party, do you have any other closing comments? You have 3 minutes if you'd like to take them. Not necessary if you don't want to.
No, thank you. Okay. We appreciate the approval. I would just say to the last comment, there is an existing building there, and to the extent this doesn't go forward, something will go forward on this site. We can lease it as an office use today and just put office operation back into that project, or we could be back here to redevelop it to a different use. But we appreciate the consideration of the project as it's presented today and the process we went through to review that project given the qualifications and attributes of that project. Thank you very much. Yep, sorry.
Evening,
Yes.
Madam Mayor, members of the council. My name is Coney Danielson with David J. Powers and Associates. We're environmental consultants, and we assisted the city with the preparation of the initial study. And I did want to just address one comment regarding the cumulative air quality analysis that was completed. And what the appellant is suggesting is that the city should use what's called a list approach for cumulative impacts, where you look at the other projects that are occurring in the vicinity of a project and you consider their combined effect. That's one approach that's allowed under CEQA. CEQA also allows you to rely upon projections in a plan for an area. And that's what the Air District does. The Air District is not recommending for nitrogen oxides that you look at surrounding projects because nitrogen oxide is a regional criteria pollutant. So it doesn't matter whether the emissions are in Santa Clara or Vallejo. The fact that they're occurring within the Air Districts, with the San Francisco Air Basin as a whole is the point. And so for that reason, the Air District has done modeling for the entire Bay Area in its most recent clean air plan and has said that you should apply the district thresholds of 54 pounds per day or 10 tons per year. And that's why you don't consider what's happening across the street or a mile away or 10 miles away. The district has already done that through its modeling for the entire Bay Area region. So the approach that's being suggested isn't workable for this particular pollutant because it's a regional pollutant as opposed to more localized emissions like construction toxic air contaminants, which it would matter whether the use was across the street or a mile away. So the list approach that they're suggesting really isn't workable for this. And the Air District's guidance is what we've followed, and it is the reasonable approach because this is it's smog, it's ozone, it's air quality affecting the entire Bay Area as a whole. So therefore, focusing your analysis just on the 17 projects within a mile wouldn't be meaningful. The district's threshold is to apply the 54 pounds per day, which we've done, and the modeling that we've prepared shows that it's less than significant with the mitigation that was included in the project.
All right, thank you very much. Okay. Do I have a motion to close the public hearing? Councilmember Davis? So moved. Please register your vote. Motion to close the public hearing passes unanimously. Councilmember Davis?
Oh, thank you, Mayor. So after listening to both sides, and I'm so glad that somebody explained to me about the generators, I really believe in Silicon Valley Power, and we don't have that many outages. I can attest to that. That's our pride and joy, owning a power plant. I would like to make the staff recommendation to overrule the appeal and uphold the Planning Commission adoption of the mitigated negative deck and the mitigation monitoring or reporting program. 2, to overrule the appeal and uphold the Planning Commission's approval for architectural review for the data center project located at 2305 Mission College Boulevard, subject to conditions. I think there were some conditions of approval that were stated in our packet. So that is my motion.
All right, we have a motion and a second on that. Any discussion by council members? Seeing no discussion, please register your vote. So it's a motion to overrule the appeal. And that passes 5-1. Okay. Thank you all very much for your presentations and for staying this late. We appreciate it. We'll continue on. So the next item we have on the agenda is action on agreement related to college football playoffs 2019 national championship at Levi's Stadium. Is that the next item?
I'm sorry, Mayor, we're actually on agenda item number 5.
Did I miss something? Sorry. Oh my gosh. Okay, next item is the public hearing, the action on a resolution approving the findings from the traffic impact fee nexus study and setting the rates for the traffic impact fee, and action on the introduction of an ordinance making corresponding revisions to Santa Clara City Code Section 17.15.330. Good evening still evening.
Yes, it is. Good evening, Mayor and Council. Craig Mobeck, Director of Public Works, and tonight I'm here to present on the traffic mitigation impact fee update for the City of Santa Clara. And so what I want to do is just go through a quick history of the impact fee, go through the methodology that we utilized to come up with the new proposed fee, and then go through some of the conclusions of that report as well as staff recommendations. So the overall fee was established in 1988, and the intent was that it's a one-time charge for development projects. And the purpose of it was to charge development for the increase in impacts in the new development and put that towards building capital projects related to the transportation network so it could accommodate the new growth. Those fees need to be established on a reasonable connection, or what we call a nexus. So whatever we're building and collecting the fee for, that it's tied to the new development. The program's been updated 3 times in the past, in 1997, 2009, and 2010. And each time that it's been updated, we've updated the project list. And so we'll go through those items with you. So the current impact fee, let me just go through that with you right now. So currently, projects that come through, the office and R&D projects are charged $1 per square foot. Industrial projects are charged 67 cents per square foot. And then warehousing, utility, and communication projects are charged 20 cents per square foot. And then there's a hotel motel fee of $400 per room. And so I did want to bring up 3 things that are pretty unique to Santa Clara's fee. One, there's currently no charge for residential, either single family or multifamily. There's currently no charge for retail. And also, if you look at the map to the right, you'll see the area in gray. The impact fee only corresponds to the area north of the railroad tracks in gray. It's not applied anywhere else in the city. So the overall update that took place, we hired Hexagon Transportation Consultants. They do a lot of work in the Bay Area associated with impact fees for various cities. We took a look at the future growth levels in the city according to the general plan through 2040. And we looked at what the impacts were associated with that. And those impacts were the peak hour trips that are increased related to those developments. And based on that, we came up with a project list to mitigate those impacts. And with that project list, estimated costs associated with it. We looked at the various options related to charging the fee with the different land uses, as well as if we were going to look at different boundaries or charging a citywide fee. We had several outreach through emails. We had a meeting with developers in the city on June 12th to go over this updated plan with them. We also posted it online so they could see it prior to the meeting. We posted it several weeks ago. So just a quick update, how are the fees calculated? We look at net new vehicle trips. So we look at developments, again, according with land use in the general plan. And when we took a look at that, there's approximately 31,000 new trips on full build out on what we could expect. And we talked about the project list that we took a look at. We developed a list and went through the dollar amounts, and it really equates to $37 million worth of unfunded projects that would help mitigate that new development. And we took that $37 million and divided it by those new peak hour trips of 31,000. And you roughly get approximately $1,200 per trip fee. So any development with a new peak hour trip is approximately $1,200. And then there's factors that you apply to that $1,200 fee so you can equate it into the various land uses, and then we can set up our fees, how we charge development. And I'll run through that in the next slide. So, but first let me go through that dollar amount I referenced, the 37 million. So when we looked at the overall projects and we came up with, there was $60 million worth. But then there's also fees that we've collected in the past. There's projects that we've done in the past. And so when you take those out of the equation, that's where you're left with the $37 million in unfunded projects. And further looking at those dollar amounts, there's really three buckets of improvement projects related to it. There's the transportation operational improvement projects. And so those are things like adding new signals, doing modifications to signals, intelligent transportation systems where we can have the signals coordinate with each other so it makes for a more efficient travel through the corridor. And then there's a bucket of the transportation capacity improvements. So most of the city, the roadways are built out, but these improvements are adding turn lanes, widening lanes, things of that nature. So it's a smaller dollar amount, just under $5 million. And lastly, there's the bicycle and pedestrian facilities. So there's a larger group of these projects. The city's embarking on the pedestrian master plan, the bike master plan, as well as the creek master plan. Projects will come out of that. So there's approximately $18 million worth of projects associated with that. And that led you to the $37 million of unfunded projects. So now looking at what we're proposing in terms of fees. If you look at the column on the left has the land use. The next column is what the existing fee is, and then the next one over is the recommended. So we looked at different options. This is the option that we're proposing for you tonight to consider. If you look at the office and R&D, you see currently it's $1 a square foot. What we're proposing is an increase of about 36%. And then when you go through and look at industrial and the warehouse and utilities, that fee's up, those are both up about 10%. And then the hotel motel is up to about $700 versus the existing $400. And so that's an increase of about 77%. And then the other three new fees that I had mentioned earlier, those are listed here with the multifamily residential, the single family residential, and the retail. And one thing I did want to point out is the city of Santa Clara's fees are amongst the lowest of neighboring cities right now with the existing schedule. And even when we look at the increases under the recommended fees, it's still one of the lowest considering the neighboring cities. I also wanted to discuss some exemptions that we looked at. So in looking at these new fees, we looked at a few different things on exemptions. One, affordable housing, recognizing the city's policies, goals associated with that and wanting more affordable housing. We thought that was important to look at exempting affordable housing projects from the impact fee. We also looked at retail less than 50,000 square foot. We recognize the importance of the small retail, what it brings to the community. We certainly want to encourage it. When you have smaller local retail, people tend to walk to it, bike to it, so that is an improvement for the city in terms of trips. And so what we recommend is that less than 50,000 is exempt, but when you have larger retail greater than 50,000, then we would still charge the impact fee. And then lastly, it's the adjustment of the fee annually. So this can be considered will be considered annually if approved, and it's based on the Engineering News Record Construction Cost Index. So that would help keep the projects up with the escalation in cost. So in terms of overall recommendations, what staff's recommendation to you is to approve the expansion of the TIF area to citywide, to include the residential and the retail uses that I described, and the ability to adjust the fee annually. Again, this is really to make sure all development pays its fair share for those improvements. Recommending the fee exemptions for affordable housing and retail less than 50,000 square feet. This helps to meet some of the city's other policies. Recommending adoption of a resolution approving the study that was presented tonight, as well as setting the rates. And then lastly, approving the introduction of an ordinance, making corresponding revisions to the Santa Clara City Code, and that's really to add those land uses that I talked about with the new fees, so then we'll be able to charge them. So that concludes the presentation, and we're available for questions.
Thank you. Thank you for that excellent presentation. Council comments? Councilmember Mahan.
Actually, you answered a few of my questions already, but just to make it clear, this is a one-time fee that's paid by the developers, correct?
That's correct.
And at what point in the application process are these fees collected or charged or whatever?
So typically the fees are collected and charged after the entitlements.
So if we adopt this tonight, do we have projects that are in the pipeline that would be subject to these fees, or are there some that are already past that point that they would no longer be subject to these fees?
Yeah, so when the fees will go into effect based on the report and what the recommendation is 60 days after approval. Now we have to come back and do a second reading for the ordinance change, and so it would be 60 days after that. And so if we come back, say, in the August timeframe, then you're looking at 60 days after that they would go into place.
So projects where the application is complete and the applicant has received actual entitlements won't be subject to the new fees, but if they're already in an application process, but they don't have their entitlements yet, they'll be subject to the new fees. Is that right?
That's correct.
Okay, thanks. Well, I'm prepared to make motions to adopt the staff recommendations when it's appropriate.
Councilmember O'Neill.
Thank you. I just wanted to clarify for myself that so I saw the list of projects and what you're estimating the cost would be, and then you've got the methodology for figuring what a per trip cost, and you've come up with these. You've equated this back to square footage or charges. So, are you thinking that with the level of fees that are set, because once again, even though we're currently like at the bottom, and I think a couple of times Councilmember Davis and I have said, we need to be increasing these fees. Don't come back again without increasing them. So we've moved them up a little.
Not that squeaky voice.
Yeah. Well, we've heard a lot about that, though.
Yeah. So, we've moved them up somewhat. I mean, they're quite dramatically below some of the other surrounding jurisdictions, what they charge. Is it your feeling that we're going to be able to generate enough revenue from these fees to actually do all the mitigations that are listed in the study?
Yeah, so the money will come in as the development happens. So certainly there, this was all based on the 2040 and the general plan. But certainly if development slows, the money's going to slow, and that'll, dictate how we move forward with implementing the plan. But, obviously you don't need the improvements, until the actual development occurs.
So one of my favorite topics I'll pick up. So the 18 and change million dollars for, like bike and ped improvements. So we've kind of seen that number, but most of the time, what it comes down to it is that what the members of the BPAC hear is that, oh, well, we don't really have a source of funding for those bike improvements, so we have to go out and get a grant. And thus why those improvements are stretched out over a period of many years. So are we now saying that the bike and ped infrastructure will start getting funding from these fees?
Yeah, so part of those fees, you saw the $18 million. So as development comes in, we'll be collecting money for it. But, not only doing improvements, but also collectively going after grants with it. Because as we talked about with the PED master plan, the bike master plan, the trail master plan, there's a lot of projects out there. We haven't completed some of those studies yet, but, you can estimate based on the numbers, there could be $50, $60 million worth of projects easily. So utilizing some of that money for grant matches to get more money in is definitely going to be helpful for us.
So as the money comes in, we definitely are going to start allocating some of it towards the bike and pedestrian infrastructure?
Yes.
Manuel, do you have?
Yeah, just a quick note for the council that just like every other project that we do, that the fees associated with these projects and the development of the projects, the council will have an opportunity to weigh in where the priorities are at as part of the capital budget process. So staff's going to make recommendations with the traffic impact fees, and certainly there's going to be different types of projects along the way. But ultimately, the council will have the opportunity to weigh in and let us know if those are the appropriate projects or if the funds should be put somewhere else as well.
Okay, thank you.
Thank you. Any other council questions on this? Seeing none, it is a public hearing, so are there any members of the public that would like to speak? Please come forward. Jennifer, I don't have any cards, correct? I know Mr. Jane's coming forward, but just wanted to double check. Welcome.
Good evening, Mayor and Council. As you know, over 40% of Bay Area residents are considering moving out of the Bay Area. I consider traffic to be a form of pollution. If somebody wanted to build a chemical factory next to our rivers and dump their waste into the rivers, we wouldn't allow that. If somebody builds these development projects and they spill traffic onto our roads, it impacts quality of life for our residents. So we need to be charging these impact fees. Affordable housing and traffic are the #1 complaints of people that want to move out of the area. On May 31st, I attended Prospect Silicon Valley's Innovation and Impact Symposium. One of the presentations was from RSM, and they actually did a study in Santa Clara of the Tasman-Zanker intersection and estimated that putting intelligent signals in, they could improve traffic flow by 10%. So we really need to consider these modern technologies and upgrade our infrastructure in the city. We also need to work to incentivize VMT and bike share programs and some Lime bikes or birds or whatever we need to do to get people out of their cars and mitigate traffic. In the Nexus study, I saw there were 5 options. I believe that staff is recommending option 5. That's the very least we should be doing. If we do nothing, the city would be on the hook for $30 million. Right now, with option 5, the city's share would be $7.7 million. I believe that being the lowest is not something we should be proud of because, as you know, traffic impacts everybody. Anyone who's been impacted by the new Apple campus understands all too well that the city took its eye off the ball and didn't ask enough from Apple. So being the lowest is going to really impact the quality of life for our residents, and I urge you to at least do option 5, but we could do more because, as you know, the city would be on the hook for $7.7 million. Thank you.
Thank you. Any other member of the public? Okay, is there a motion to close the public hearing?
Second. Did somebody say so moved?
You can still ask a question.
Oh, okay.
Yeah, so there's was there a motion?
So moved.
Second.
Motion second to close the public hearing. Please register your vote. And that passes unanimously. Councilmember O'Neill has a question. Councilmember Mahan has a motion.
Mr. Mobic, so my question is, you know, and because like I said, I noticed to look at the level of the fees and looking to compare to other cities, and the 7.7 million that the city will be on the hook for. Was the feeling through the study to create, you know, for the nexus, that the nexus only justified the level of fees that we were the staff is asking for?
Yeah, I mean, that's how those fees were justified, but on the 7.7 million, then we can come up with that money. There's money coming in through other developments and things like that. So we don't see the 7.7 really up front being an issue, but as Suds mentioned, if you go to the other options, then that number starts growing all the way up to 29 million, where that's a whole different story.
I'm just curious, so why are some of the other cities so much higher in their fees if they're having to do, I would think if they're doing the same sort of, you know, analysis to establish a nexus, that, and you know, and most of them don't have, I wouldn't think, have as much development going on as Santa Clara. So I mean, it seems kind of funny that, of course, I know you don't know how they did their studies. You may know how Sunnyvale did theirs, but it just kind of jumps out at me if everyone's supposed to be using a similar methodology to establish nexus, and around here, most of these cities all have a very comparable level of development. How come the fee, you know, is there a reason why the fees would deviate as much as they do?
I think some of it depends on the level of improvements that they're speculating need to be implemented based on that new growth. So as that project list goes up in dollar amount, then in order to account for it, your fees and your square footage costs would then rise.
Okay, so that's how they're getting all those fancy bike highways. Okay, all right, thank you.
All right, thank you. Councilmember Mahan, you had a motion?
Certainly. And I'll ask the city attorney, can we take them all together or individually?
You can take them together if you all think you're going to vote the same way.
All right, I'll take that chance.
On each of the motions.
I'll move then to approve option 5 from the traffic impact fee nexus study, which expands the fee area to citywide, includes retail and residential land use, and exempts retail establishments under 50,000 square feet and any affordable housing units built as part of the development, and adjusts fees annually in line with the latest construction cost index for San Francisco as published by the Engineering News Record or equivalent, and to adopt a resolution approving the findings from the traffic impact fee nexus study and setting the rates for the traffic impact fee, and approve the introduction of an ordinance making corresponding revisions to the Santa Clara City Code section 17.15.330.
Second.
Thank you, and that is the staff recommendation outlined in the report. So there's a motion and a second. Is there any other discussion on that? Please register your vote. And that passes unanimously. Thank you very much, and thank you, Craig, so much for that report. It's an excellent report. Okay, our next item is the action on agreement related to college football playoffs 2019 national championship at Levi Stadium, and this is a stadium authority item. Executive Director.
Good evening. I just want to announce before I start a presentation that our stadium manager was here. He was in a great deal of pain, and he said that it would be difficult for him to continue, and he isn't here. But I am prepared to make a presentation by either PowerPoint or just a verbal summary. How would you like to proceed, just given the...
How about a verbal summary?
Sure, absolutely.
I think the question is to make sure that we are, you know, not making the payments on...
That's right.
What was promised at the public hearing. I'm sure that's what everyone's interested in.
In short, the terms, the council has had 2 different sessions on this item and has expressed its terms publicly. Staff then followed up with with Mango, and I'm happy to report today that the terms that you set us out to accomplish have all been achieved. Included in your packet is an executed agreement by the stadium manager, and I'll just go through very briefly what your terms were and how the city resolved them. On the first matter of no financial losses to the Stadium Authority, in writing in your agreement, the Bay Area Host Committee has agreed to accept all of the CFP-related cost for the game day, the pre, during, and after event cost. And included in that is the double time pay for public safety costs, recognizing that public safety cost is inclusive of other departments besides police. On the second matter was full audit rights, and we looked at this item from two different perspectives. The first is for the Bay Area Host Committee to provide a complete accounting of all revenue and expenses and possession of both soft and hard copy supporting documents for the CFP event. And the second requirement is for the Bay Area Host Committee annual financial audits to provide those for the fiscal years that contain the Stadium Authority related expenses, recognizing that the event may span over a couple fiscal years. On the other matter related to not pre-funding any CFP-related events, at one point we had showed you a scenario of a four-party agreement recognizing time and working with outside parties. It seemed simpler to have the city receive payment to provide direct invoicing to the Bay Area Host Committee, receive payment within 15 days, so that in turn we can pay those the CHP and the Sheriff's Office within 30 days, so that we don't advance any of our general funds. And they have agreed to those terms. So with that, I think all of the terms that the council has set out have been agreed upon. They're reflected in the document, and I can recommend that that you approve the assignment and assumption agreement for the national championship game.
All right, are there questions? Authority Member Mahan.
Thank you. I just wanted to thank our city manager, and I'm sure our city attorney had a hand in it as well, in coming up with this very good resolution and getting everything that the city needed, the Stadium Authority needed and the city to move forward with this. So I would move to approve the staff recommendation as submitted.
Got a motion and a second, and I also want to thank the staff for negotiating this contract, which is precedent-setting for the National Football Championships, considering the last host cities had paid tens of millions of dollars of public funds towards this game, and Santa Clara will not be paying any money towards this game, and could possibly benefit from some revenues from the game, which is the intent of Levi Stadium. So thank you very much for the good work and putting it together. So if there's no other questions or comments, please register your vote. And that passes unanimously. Thank you very much on that. Next, we have reports of members and special committees. Councilmember Davis.
Thank you, Mayor. I would like to add on to an agenda item for August 18th, please, for a donation sponsorship item of a no-fee permit for nonprofits and qualifying institutions that will streamline the process. We were given a letter recently, and I would like the staff to bring back the analysis of how we could put this into practice for the 28th, because we did receive a letter, and I would like to at least have this looked at so that we can help out these people, these nonprofits. So can I please add that to the agenda of the 28th?
If that's the pleasure of the council, then we would.
Can you explain what you're trying to do?
We received a letter from the Portuguese SES Hall, and they requested us to help them with something that's been going on in the city of Santa Clara for years. And they've asked us to help them again because the impact fees that we will impose on them, they just can't simply afford. So there's got to be a way of maintaining the quality that we've had for Santa Clara and not really penalize people. So I'd really like to take out, or look at this a sponsorship fee for a nonprofit. and how can we help these people? So if you could bring that back on the 28th, I would love to hear some kind of.
Can I ask something? Aren't we working on that already? City manager?
We on August 28th, the formal donation and sponsorship policy. You've been taking action outside of a formal policy set one by one. But what Councilmember Davis is referring to is there's instances like yesterday's where there was itemized items and some unknowns. There's instances out in the community where there are special events where the city in the past has either waived or absorbed the cost of providing sponsorship for the event. It is presenting challenges with the process that we're trying to put in place. The city attorney and I had an opportunity to talk briefly when the letter came in from the group, and our quick and best thinking is to evaluate a no-fee permit that allows for us to maintain the sponsorship and of these community events, remove some of the issues that have surfaced in some of the recent discussions with these community groups, and frankly, just simplify the process. We did think, though, that we should bring back the level of subsidy and waiver, given that as a past practice, the city has engaged in quite a number of waivers and sponsorships, just so that you have that data available to as you make the decision. But what we had talked about internally is how we could be responsive to the letter in a way that is reflective of work already underway.
So that particular instance, could that be part of the report for the 28th?
We would.
So
if
that's what I was saying.
Yes, if that's the pleasure of council, then we'll add that work from here to August 28th.
Make that part of it?
Can you?
Okay,
Will
everyone's nodding their head yes.
Everybody get the letter? Thank you.
Anyone in opposition to that? Consensus? Thank you. City Attorney, did you have something to say on that?
We'll bring back several alternatives for solving the problem.
Thank you.
Okay, thank you very much. Thank you. Okay. I just wanted to report that I had the honor of representing the city of Santa Clara at the Silicon Valley International Invention Festival held at the Convention Center on July 2nd or 4th. And each year, the International Federation of Inventors Association, it's called IFIA, and Korea Invention Promotion, KIPA, hosts this International Invention Festival to bring together the best inventors from around the globe. It was so interesting. But this year, they chose our city to host their first ever Silicon Valley Invention Festival. And they plan to have this festival here also next year. So in honor of the festival, they presented this beautiful medallion in this beautiful box to the city of Santa Clara, commemorating their 50th anniversary. So I wanted to show the public that they gave us that. And it says on here, 24 karat gold. I don't know if it's true or not, but it's on the box. And it's under the lock. So I brought it back for the city, and then they also gave me this medal, International Inventions Medal. But they were very excited. Unfortunately, they had their event on the 4th of July. They didn't realize it was a holiday here. And so next year they're going to have it at the end of June. But they did bring inventors from all over the world to the convention center, and they had very interesting inventions. But they were very excited to be here in Santa Clara, the center of what's possible, and they'll be back next year. So I just wanted to report that. Any other council members? Anything? Okay. City manager, executive director reports?
I know it's late, but I would be remiss if I didn't thank our staff for a couple of key items. The first is on the 4th of July, over 200 staff members supported this incredible event that we had at Central Park to celebrate our Independence Day. The event included volunteers, it included staff members, but this park also welcomed 35,000 attendees throughout the day, and so that's significant. It was a great event, and I'm still hearing from folks around the community their pleasure with it. I also just want to acknowledge that over the past couple of months, the City Council has addressed quite a number of meaty policy items. And before we leave for your recess, I have encouraged staff to take a little bit of time off. There's a high level of exhaustion. Some of the folks in the room are feeling it. But
We can't see, we're so tired, our eyes won't open.
We are appreciative of the recess, and I want to acknowledge all of the good work that has come through, particularly in the last 2 days, but really acknowledging that staff has really stepped up over the last couple of months to serve this council well. So I did want to put that thank you before I went on my own vacation, but before the council went to recess.
Thank you, and thank you for pointing that out, and we do appreciate everything staff does for us. We don't make it easy on you. We have all these items. We started at 4:30 today, and it's midnight, but thank you so much, and please enjoy the council recess as much as you can, and we look forward to coming back the end of August and starting all over again. But we only have 2 or 3 special meetings between now and then. Please stop scheduling them. Okay. Next, we have, tentative meeting calendar. That's not an item. So we do have an adjournment. Hold on while I find that. Thank you. Going to ask the council to adjourn in the memory of Braden Varney. He was a heavy fire equipment operator, CAL FIRE Madera Mariposa Merced Unit. We offer our heartfelt condolences to the families and friends of CAL FIRE heavy fire equipment operator Braden Varney from the CAL FIRE Madera Mariposa Merced Unit, who was tragically killed while battling the Ferguson Fire in the Sierra National Forest on July 14, 2018. As a dedicated community member, he protected the area where he grew up by serving in the California Department of Forestry and Fire Protection's Madera Mariposa Merced Unit for a decade. He is survived by his wife and 2 children, 2 young children. Our hearts are with his family and loved ones. Let us please have a moment of silence in his memory. Meeting's adjourned. Thank you all.